being organized the ADR Advocacy Competition 2025. Taac is a unique initiative that takes participants through the entire journey of dispute resolution. From the very inception of a dispute to the enforcement of an arbitral award, it is designed to provide immersive hands on training while refining essential advocacy and problem solving skills in ADR. Today's workshop focuses on one of the most crucial aspects of legal practice, that is client counseling. Effective client counseling goes beyond giving legal advice. It involves listening, understanding client concerns, asking the right questions, and offering practical ethical solutions. This session aims to help you strengthen those skills and approach client interactions with greater clarity and professionalism. To guide us, we are honored to have Ms. Niharika Gupta, a corporate and commercial law professional with an LL.B and an LL.M in corporate and commercial law. Her expertise spans corporate advisory, dispute resolution, insolvency, compliance management, and regulatory representation. And she has advised clients across industries ranging from aviation and banking to real estate, IT, and pharmaceuticals. She brings with her not just legal expertise, but also valuable practical insight into client relations, making her the ideal mentor for today's workshop. Welcome, Niharika, ma'am. Over to you.
Thanks, Faris, for such a brief introduction. So, it's my pleasure to connect with you all, and I really appreciate to get the opportunity to be connected and share some insights that whatever I have learned until now in this field. Because in the field of law, learning, I believe, never ends. A lawyer can die, but not the law. So this is like full time or full age journey that we are into it. So I will also just give a brief, short summary about myself. That after completion of law, I chosen corporate and commercial law because I was very interested in corporate law back in BLLB. Thereafter, I have worked with a energy and environmental consulting firm in UAE. After working there, I have jumped into insolvency and bankruptcy and have worked in core corporates from organization to reorganization. And thereafter, I have started working with multiple business units. Till the time today, I have realized that a lawyer can work in diverse fields of law, but first and foremost, and the fundamental thing that needs to be taken care is how you approach the client, how you counsel the client, and how you can become a good lawyer in that perspective. So today's session is particularly with regard to client counseling. So we have often known or listened that most people do listen with the intent to not intent to understand, but intent to reply. I believe in general perspective of life and particularly in law, you cannot just listen to reply because that only and only works in the courtroom, and a lawyer's work does not starts and ends in the courtroom itself because it starts from a client. So I will just give you an example. So for example, you are sitting across with a client. He has been terminated unlawfully and he is very angry, sad, upset about the things. First and foremost, would you be thinking from a lawyer's perspective and bringing all the labor law, compensation, notice period, unlawful termination, or you would rather choose to listen to that particular client? I believe the approach should be to listen to that client. So we have to use that strategy that we will also discuss in further slides. That first we need to listen and then we need to give our inputs or understanding on that perspective. A lawyer should not have any presumptions from the very beginning. So, for example, if somebody comes to you, he has been terminated. A lawyer should not have any presumption in mind that the employee must have done something wrong that has been terminated. Or my client must be right, the company has done something wrong to my client. Always listen with a poker face and without any presumption or prejudice in the mind. Because law solves problem and listening reveals which problem needs to be solved. So today we will focus on what not what lawyers say, but what lawyers listen. So by the end of this workshop, I believe that you will understand what is the importance of client counseling in the legal practice. You will learn the core skills that helps in client counseling, apply a structured counseling framework, and identify common mistakes which are need to be avoided. So I have just one question before we begin or jump into the main context. What do you think that client values more? First, a lawyer's knowledge of law, or how the lawyer makes them feel during the first meeting? I would really appreciate if we can get some answers. Yes, I can see one raised hand from Taac 062.
Yes, ma'am. I would say that as long as you can convey that you have a base level of knowledge about the law, they will focus more on how you make them feel as a lawyer.
Okay, okay, that's good answer. Anybody else?
Niharika, there are answers in the chat box. Tag 072 says second one, 51 says second, Krishnadas says both, 55 says second one, Khushi Pandey says second. Everyone says the second point.
Okay, so I would need one volunteer to speak on the behalf of that why they believe that the second one is important. Anybody can speak up.
Raise your hand, guys, whoever would like to volunteer in speaking.
Ma'am, can I answer this question?
Yes, sure.
Ma'am, I believe that a lawyer's knowledge of the law is secondary. A person first need to think how the lawyer interprets his intentions, his information, how he interprets the client. So a lawyer's knowledge of the law always becomes secondary to a client. He can't interpret a lawyer's knowledge on the first meeting. Whatever he can interpret is the thing that how the lawyer makes him feel during the first meeting. Is the lawyer is able to understand his problems? Is the lawyer is able to understand his grievances, and can he work upon that?
Okay, okay. Thank you so much for your answer. So I stand whatever you have said. I'll just make an addition. Both of them are equally important because in the first meeting, it is very, very fundamentally important that how you make other person or the client feel. But at the same stage, you also must have some knowledge of law because in the first meeting, you can ace that part by making them feel heard, have some empathy. But in the second meeting, when they'll understand that, okay, this lawyer does not have the knowledge of law, then in that case, they're going to switch to another lawyer and for the same consultation part. I'll just give you an example. Let's say you go to a dentist. First, dentist will take consultation. So in the consultation, you will tell the dentist that, okay, I have this and this thing in my tooth, and what should I do further? First, you want the dentist to listen to you. That where you have the pain, what are your concerns, what do you want? At the end of the consultation session, you also want the dentist to tell you that, okay, what are the further steps? You want root canal treatment, you want to have eradication of that rule or that canal, or you need something else to do with the tooth. So both are equally important, but first and foremost is how you make the client feel. And second is how you can bring law into the table. That is also from a layman perspective. So I am on the part that equally both are, we need to take them hand in hand. Okay. So further, Abraham Lincoln has said that a lawyer's time and advice are his stock in trade. After spending so much time with the clients, I have realized that our real stock in trade is something even more fundamental. That is our ability to listen, understand, and then counsel our clients. How we can ace that particular part is from our role. So back in BLLB time, when I was doing internship, one of my mentors taught me our role. So he has said that every time we are in the profession or any profession where we are in service, we have to provide services to the client, we should apply our rule. because our means us, hum. For example, if I am doing a project with Faris, if I'll say, Faris, this is your project, we're working on your project, Faris will not able to connect with me. But if I'll say, Faris, this is our project, we will work on our project, then Faris will be able to connect with the project. So this is how our rule works, which means observe, understand, and react. In client counseling, I believe this is the first and foremost rule, that when a client comes into your room or enters from a door itself, you have to observe the client without even saying a word. You need to just observe how client is behaving with you, how is he sitting, because then only you will be able to deal with the client. Because when you will be dealing with the clients, it's not something a very straight line, because every client, every case is different. Sometimes clients will come to you with a concern, sometimes clients will comes to you with a very angry emotion. Many a times clients will come for a just basic advisory, so you will have to deal with them from case to case basis. Once you observe the client, you need to understand them. As I have given you the example that if a client comes to you and he has been terminated from the company, first, you need to understand that now what does the client wants. First, does he want to take a revenge from the company itself? That they want to tarnish their image, they want to threaten them, they want to rejoin the company, or he wants to remove that terminated tag from himself so that he can join another company. So, as mentioned, that to solve a problem, first you need to understand what problem needs to be solved. And when you cross the stage of observance, understanding, only then you can react. And in the react stage, in the first meeting itself, never ever give whatever you feel is the legal opinion you want to give. Take your time, understand the case, and then give your legal opinion on the same. So, what is client counseling? Client counseling is lawyers' first meeting, or I would say first interaction with the client to understand their concerns. It is meant about listening, clarifying, and advising responsibly. Because as lawyers, we have great responsibility on our shoulders. Let's assume I am advising a company. Now that company is relying on my legal advice. And any of my legal advice, which is not as per the laws and the rules, can attract hefty penalties on the company. So we always carry a very heavy burden on our shoulders, which needs to be delivered with a huge responsibility. Client counseling bridges the gap between you and your client. We will take a small example that we can provide you, in Taac, we can provide you client counseling material to read about. You can read about that material and you can still learn about that what is client counseling, or you must have also googled it or read on the research papers or anything that what is a client counseling. But if there is one-on-one round, if today we are organizing this workshop and this is the round that we are doing, you have any doubts, you can bring upon that in the chat box, you can bring upon that, you can speak up, we can have a conversation. That is how you can dissolve all your doubts in the topic. So this is about the creating a bridge between you and your client. Because of that, you can build trust, clarity, and confidence. And every relationship, be it personal, be it professional, it comes along with the trust, clarity, and confidence all the times. And when you fulfill all these steps, then you can create a long-term relationship. You must have heard in the law that a lawyer must have a social connection. How that social connection builds? When you have a client and when you are being a very good lawyer for that particular client, you will be connecting to the relatives of that client, friends of that client, and that is how you're going to make your social circle. And that is how the referrals work. So when you have one client, you can assume that in the long term, you can bring 10 more clients from one client itself. So after that, we will speak about what are the core skills of client counseling. As we have mentioned, active listening. So active listening is something, it's not just that you are listening because we listen from our ears only. That's a fact. But we have to make the gestures in a way that the other person feels that, okay, somebody is listening to me. One example is not. As I cannot see most of you on the camera, otherwise, I would have given more examples. I have just one example of Faris because he's on camera. So, for example, when I'm saying something and Faris nods, so I am reflecting, it is reflecting to me that, okay, I am making sense to him. Whatever I am saying, he's understanding or he's listening. Second one is maintaining eye contact. Let's suppose I am speaking, I am working, I am looking here and there, and you will not feel connected because you will not feel that I am speaking something at the same time. If I'm speaking and Faris does his own work, writing somewhere, looking here and there, I will feel that, okay, either I am not making any sense or he's not attentive. Other one is reflective listening. So whenever somebody is speaking to you, you just not need to listen only. You need to reflect sometimes. For example, as I have given example of the termination case. So as a lawyer, you can ask questions in between. Oh, so you have been terminated without any notice. Then the particular client will give you more information that, okay, he has not been given any notice. He has been terminated immediately. So you don't need to push him or speak more than the client, but you can have a reflective listening by saying some things. When you talk over the phone to the client, how will you make the client feel that you are listening? By reflective listening itself. That, okay, yes, yes, okay, agree. That is how you speak over the phone. So these are the some techniques I believe. I am not sure today I am making any sense to you, but when you will be speaking to your clients and then they'll ask you, Vakil Saab, are you listening? Then in that case, you will realize that, okay, I need to make more gestures to make other person being listened. Other than that is questioning technique. Sometimes what happens, lawyer, a policeman are the profession. People are not very friendly to talk to, or mostly people are afraid to talk to. So you have to keep your questions as polite as it could be, as minimal it could be. So there are some techniques to ask question as well. First is open-ended. So let's assume you have a client who is not very spoken and who is not, you are not able to understand. But at the end of the day, you need facts. That is how you're going to prepare your case. So you need to ask for the details by, is there someone?
I
Okay.
think that was accidental, ma'am. You can continue.
Okay, no worries, no worries. So, okay, I was an open-ended question. So you need to ask in detail that, for example, the terminated employee, he is not able to express more that what has happened in his case. So you can ask question, okay, tell me in detail. So, okay, where were you? How long you have been in the company? How was your experience in the company? That is how you're gonna make that particular employee comfortable with you. After that, closed questions for precisions that when you were terminated, how long you have worked in the company, and then what was the date of notice period, how many dates you have served the notice period. So these are the precise questions which you can use in your case. Then there is funnel approach. Funnel approach is something every client have a story to tell, but it is not important that whole story is important for your case. What you need to filter that information. First, you will understand or listen to whole case. Then you will narrow it down. Then you will narrow it down to a point that, okay, now this is the close filter. Then you're going to confirm the facts that one employee is terminated, the whole story, his manager is not good with him, his colleagues used to bully him, and everything. You will narrow down the information to the termination, that how he was terminated, because bullying is a separate case. Then you're going to confirm the precise information that with the help of closed questions. Here, one tip is that avoid any leading questions unless you are clarifying. For example, you cannot point out your client what was your fault, what wrong did you do. You can ask these questions indirectly, but directly you cannot point out any fingers on your client because it will make them feel targeted. And then in that case, they will not be very comfortable sharing any information with you. Okay, other than that, after questioning technique, there is empathy. Empathy is something that you are not in that situation, but you are understanding that situation or that perspective. There are different kind of empathies. One is verbal empathy, that you can understand that particular emotion of your client. For example, your client comes to you with a divorce case. Obviously, he or she will not be very happy with the fact that he or she is getting divorced until or unless they have other plans. So first, you need to be very empathized with them. For example, you can say that, okay, I can see this situation has been stressful, but let us move on the facts of the case. Rather than you are being very rude lawyer and saying, okay, ma'am, keep your emotions aside, give me the facts. Then in that case, the client gonna go outside the door because he or she feels that you don't respect their emotions at that particular time. Other than that, there is non-verbal empathy that reflects towards your posture, tone, and patience. Sometimes what happens, even in friends, even in with our parents, with our siblings, we are trying to tell something, we are trying to tell a story or something, but their posture is something that they're not listening. They're doing something and they're saying, yes, yes, I am listening. But you are getting that reflection that they are not listening to you. So this is not the situation in the profession. Here, you have to be in a posture, in a eye contact, in the tone, in the patience that you are here, you can listen to them. Thereafter, which is very, very important, to make a distinction or a thin line between empathy and agreement with everything client says. Because whenever you are having a word with client and client is saying something, even though you are not with that and you are agreeing to that part, that gonna backfire when you will prepare the case or you're gonna go to the court or any of the situation, you're gonna bring up the law. Then client will say, in the first meeting, you have agreed to whatever I have said. Now you are changing your stance. So you need to be very, very careful where you are empathizing and where you are giving a consent or agreement to whatever the client is saying. That is how the next step you can achieve, that is managing expectations. Because I have not seen any client who has come to me with the expectation of not winning the case or not winning answer. Every time client will come to you with a winning situation only. So you need to give a reality check with all the core skills that you are listening to the client, you are questioning them, you are showing empathy, but you are also setting the expectation that, okay, we will try our best, but I cannot assure guarantee because everything will be done as per law. I understand what you want. Here's what the law allows. Also, in the cases where you feel that, okay, legally this is not possible. So, in the first instance, if you will say to the client that this is not possible at all, so the client will not come to you again, and this is not how you're going to make your client. You can say that this is very tough to achieve. However, these are the alternative options we can explore. After that, there is confidentiality and boundary, which is also last but not the least core skill for the client counseling because When I am sharing my secret with somebody, I want that somebody, or I want be myself be that confident that that somebody will not share anything until or unless I want to. A lawyer's role is more or less is that secret keeper itself. That sometimes, not all the cases, but sometimes in white collar crimes specifically, clients gonna come to you, but they will not share whole the information with you because they're not sure you're gonna keep that confidential or not. So whenever you are sitting with a client in the first interaction, you have to make that statement very clear that, sir, ma'am, whatever you are sharing will stay confidential between me and you until or unless you want me to disclose that. That is how you're going to build the confidence between you and your client. The last thing that particularly I believe every lawyer need to take care is that you need to be friendly, but you are not the therapist of the client. In most of the cases, what happens when a client share information, they becomes more friendly with you. And they feel like now this is our lawyer, we can share each and everything with them. This happens not in professional setups, but when you have one-to-one individual clients, mostly this happens then in that cases where clients does not know where their boundary ends. And the lawyers end up saying that believe I am a full-time therapist to the client. And after that, they start ignoring the client. And in the end, they lose the client. So you need to make that boundary from the very beginning that you need to make a friendly yet professional relationship with every client. Okay. So how you gonna identify a problem? Let's say you are counseling a client and you have to identify a problem. How will you do that? As we have discussed the core skills, first listen actively. After that, ask open-ended questions, sometimes with a funnel technique, sometimes with the closed questions. It depends upon case to case. Then try to separate facts from emotions. Because as mentioned, that clients never gonna be very poker to you or very happy coming to you and saying that, okay, I'm stuck in this and that issue. Either in the beginning, they're gonna come you with a problem or with a legal opinion, or in the end, they're gonna come with you in distress or sadness. So you need to separate those facts from the emotions, and then you have to clarify the true objective of the client. That what does the client want? In most of the cases, we need to see that what actually the client wants. Sometimes clients wants the money, sometimes they want their reputation, sometimes they want to take revenge with the best legal possible way. So we need to explore that because as lawyers we know what our duty is, but one of the duty is to towards the client as well. And we cannot go beyond. Let's assume I have a client A. He wants so there are A, B, C solutions. He wants A solution. But as lawyer, I am pushing him, no, you go for the B or C solution. I'm not on the part of A solution. Then in that case, client will not going to be very comfortable with you until or unless you are making them understand that what are the pros and cons with going to the A, B, and C remedies. So even if you want to imply your own objective in that particular case, take the client into your confidence. Then in that case, a good case can be solved or a good remedy can be achieved. As mentioned, that objective of client counseling, it is to understand the client's perspective and concerns, identify legal and non-legal issues, provide options in clear, simple language, and guide client towards informed autonomous decision. So when we say informed and autonomous decision, as mentioned, always keep client in your confidence. Because if client is not confident with you, either you're gonna lose the case or you're gonna lose the facts. And when you don't have the complete facts in your brief, you are not gonna achieve anything. Either it's a big case or a legal notice itself. So you need to take autonomous decision with the client that how you're going to go with your case. And that can be done through client counseling from the very beginning. So here is some first meeting checklist. First you need to do is always and always introduce yourself. Explain confidentiality. And when I say introduce yourself, you don't need to tell the client whatever you have achieved so far in life. You have to tell the client how you're going to help the client with your experience, with your expertise, with whatever the cases you have done so far, which can make the client confidence. After that, let client narrate freely first. Some of the lawyers I have seen that they believe in speaking more because in law school generally we have been rewarded for more we speak, more law points we put across, how argumentative we are, how we can bring up the facts and the cross arguments. This is for what we have been told in the society as well, that the lawyers are the one you cannot beat any argument with. But this is not how it works with the client. You need to let the client to narrate his story so that you can make up the further relationship and the case. After that, ask open-ended questions. Take notes in categories. So when the your client speaking to you and having a conversation, don't just start writing, because then in that case the client feels that okay, whatever I am saying, the lawyer is taking notes and gonna use in the case. So they're gonna tell you a very short and crisp fact, whatever has happened. First listen. After listening, after questioning, then try to make notes with the facts, with the law, with emotion, and then goals. Because, as mentioned, need to separate facts and emotions, but emotions also can play a very huge role. It depends upon your case. When you are doing a corporate consulting, emotions has no role. When you are doing a personal matter, specifically family matters, then in that case, emotional plays a very, very vital role. Because let's assume you have a divorce case. Now, the client wants the divorce, but he also wants to take care of his son. So, your priority in the case is the divorce and the best take care of the son of the client. This is how you're going to go hand in hand with the client, because if you're going to focus on the divorce itself, client will feel that my second priority is not being taken into consideration. Thereby, you have to clarify goals and expectations. That because if my client wants the moon, I cannot go and bring the moon. I can tell him how he can see the moon very closely, but I cannot take that. So I need to separate that, okay, whatever my client wants and whatever I can bring that to the table. After that, provide preliminary advice. As mentioned in the beginning, that what is important, the client, how he feels about you, or how law knowledge have, how a lawyer have the law knowledge. So when I say that provide preliminary advice, it means that at the end of the consultation, you have to give very limited but information to the client, that whatever the further steps are, whatever you best can do for that client, and whatever you think is your opinion, but you're gonna check the facts, you're gonna check the brief. After that, you will provide the further information and further process, that how you're going to go with the case. So always and always in client counseling, provide advice, but very minimalistic, so that you can leave a chance for the second meeting. Because in the legal field, in other fields as well, in the legal field, what happens, a client is something that does not trust the lawyer very easily. So one client can come to you, ask for the advice. After that, with that advice, they can go to another lawyer, then take cross advice, then go to third lawyer, and then take their advice. And from these three lawyers, whatever they feel best with the advice, with the budget, they're gonna go with that. So this is how you're gonna protect yourself as well. So after that, agree on the next step and the follow-up. That how this meeting has helped you to build the case. This is the preliminary advice. In the next meeting, please bring these and these documents. Then we will have a discussion and we're gonna go with the case. Because I don't think so in the first meeting you will have all the information, all the documents, everything. You have to keep the space for the second meeting as well. And we have very common mistakes which needs to be avoided in the client counseling. First is talking more than the client. So this is one of the usual mistake initially lawyers can make, that they speak more than they should, because client is the one have story to tell. Lawyer is the one which needs to heard the story. That is how you're going to make the relationship build. After that, giving instant legal advice without any further facts. So if I am telling you what are the client counseling things today, there is a sea of information. So if today I am going to give you all the information that how does it work, why do you want to do another workshop? Why do you want to have another client counseling session ever in your life? And why you want to go with client counseling competitions and then learn out of it? Because instantly in personal life, professional life, you cannot learn anything in one go. And that is how it works in legal field as well, because law is very vast. If somebody comes to me with unlawful termination, I need to explore all the labor laws. I need to see if the company falls into Industrial Disputes Acts. I need to see if the company falls in Shops and Establishment Act. Basis on the acts, I need to see which law will apply, how I can go to the Labor Commission, which remedies I can ask for. If instantly I will tell my client that, okay, we're going to go with Shops and Establishment Act and we're going to file a case in labor court, client going to rely on my advice. But the next time when I will change my stance, it will shake the confidence. So always be very, very careful how you can give advice, very minimal in the first go. Then you can say that this is the best I can say right now. I will go through the facts of the case, and basis on that, we will have a discussion what is the best legal remedy possible. After that, using legal jargons is the one of the biggest hurdle between a client and a lawyer. Let's assume you are learning Japanese language, right? Now you are on the basics, and somebody or your teacher starts talking to you in Japanese. How would you feel? You will feel unrelated, you will have no confidence, you want to just leave the room as soon as possible because you cannot understand a word. So, this is how it works with the client, that always use, if your client is Punjabi, try to talk in Punjabi. If your client is speaking Hindi, try to speak in Hindi. And even if you don't know how to speak in Punjabi, just say Sat Sri Akal. Your client will feel very, very much relatable with you, and you're gonna have a very good conversation, even in English or Hindi. So, legal jargons you can use when you are sitting with your lawyer's friends group, but not with your client. After that, over promising outcomes. I have seen also that some clients say that, okay, that particular or other lawyer says that they can bring favorable order to us. This is not how law works. Even if a lawyer having 20 years of experience cannot guarantee what order court going to give. because it depends upon the circumstances of the case, it depends upon the nature, it depends upon the judge, depends upon the courtroom, it depends upon the timeline and multiple factors thereafter. So never ever promise anything to your client. Always say that I will do the best I can do, but I cannot assure anything. Because even if we take example of a doctor as well, in the surgery we also sign a form that if something happens to me, if I die, I am giving consent to it. Doctor obviously says that this is safe, but still you are signing that form because there is no assured guarantee of any outcome. So we need to be very careful whenever we are speaking or giving any kind of promise to a client. Now, in the conclusion, all I want to say is a lawyer's role is not just to know the law. It's about know the client and then know to law. So when you walk into a first meeting, whether in an internship or a young associate, always remember that you have to listen more than you speak. This also helps you in your professional journey because when you will start with even in your internships, you have to listen to your senior. You have to understand what are your expectations from that senior. And then you're going to search on that thing and give the result or give the outcome to the senior rather than speaking and saying, no, I know everything, I will do it. Because in the internship itself, if you will not be able to do it and if you have already committed, no, I will do it, that's gonna backfire you. After that, set realistic expectations. Build trust and not just arguments, because arguments can be done on anything. Trust can be made from very scratch and it can be lost in one shot. So you need to be very careful in the profession as well. If you do these three things, you just won't be a lawyer. Either ways, you're gonna be a lawyer. But it will make you a very good lawyer that every client wants. Because at the end of the day, clients wants you to hear her or him. He does not want you to just give the legal opinion and the things. Because sometimes it also happens that client comes to you just for the advice. Professionally, that's not the best way, but it happens that clients come to you, take the advice, and never show up. So always be very careful whenever you utter a word for giving any kind of advice. So this is, I believe, all from my side from this particular session. I will really appreciate if there would be any questions from your side so that we can have an interactive session.
Thank you so much for that, Niharika ma'am. I think it's safe to say you covered each and every aspect of client counseling, and this goes just not just limited to Taac, but in fact, I think when we progress as lawyers in the future, you made some very important points about setting boundaries, about the approach one needs to take when talking to clients, and also very important not to become their therapist, as you mentioned, setting boundaries in terms of how friendly you are and in what way you approach them and how you give out legal advice so that they don't take advantage of you as well. So thank you for that. Thank you for that very informative session, ma'am. Now we have a few questions in the chat box. Sushant has a question. Sushant, would you like to go ahead with your question?
Uh, Good evening, ma'am. Am I audible?
Yes, you are audible.
Ma'am, actually, I have two questions. This is a client counseling competition. So sometimes the client try to overtook the competition. He or she speaks too much. Or maybe
Hmm.
sometimes, like I have been to a competition, they start crying in the client counseling
Hmm.
competition over the fact. So
Hmm.
how to deal with that situation?
Okay. So in that situation, it happens and it generally happens. And you have mentioned that sometimes you are also short of time. This is not about the competition. This is about sometimes you are going to court, your number is being called, you are cross confirming something from the client, but he is over exaggerating things. Make them feel calm, first of all, make them empathize, and then make them understand that at particular that point of time, why this information is very important. and make them understand if they are not answering to the question, they're going to lose their case forever or whatever the remedy they want. First, you need to empathize with them, because if they are crying and then you are saying, please give me the information, I have the competition, I have to wrap it up, they're not going to give you any information and they're not going to connect with you from that perspective. So, just if you have 5 minutes, spend 2 minutes for the empathization and 3 minutes to taking the information.
Thank you, ma'am. And my other question is like, what points are going to discuss in the post discussion thing after the with the client? Like we have opening, then we have discussions, then we have post discussion. What points we can cover in the post discussion things?
Okay. So when you have had the discussion and in the post discussion, ask them more about the, not about the emotional thing that they are going through, but ask them that how, what they want to achieve from the case. So in the beginning and in the middle, they have told you whatever has happened, whatever they want, but try together what they want to achieve from that. What is the main target of them? Because every client does not want a remedy. They have something in the end to achieve.
Thank you so much, ma'am. That's it.
Thank you. Thank you, Sushant.
Hope that answers your question, Sushant. We have a few other questions. We have one question from Team 062, Shinchana. Would you like to go ahead?
Yes, thank you. Ma'am, I think one of my, I also have two questions. One was, what are some strategies to get information from the client when they are either they're very unwilling to give information or they're confused about the information themselves?
Okay, okay. So as I have also given an example that when you are having a questionnaire session with the client, and sometimes clients are not expressive in whatever they want to say and whatever they are saying. So you need to firstly understand the broader case. So here you have to apply the funnel technique. You need to understand the broad case. Once you understand the broad case, then you have to make up your own questions. Just note it down wherever you have any notepad or something. The questions are coming to your mind. Write it down and then try to directly or indirectly ask from the client. So, for example, if there is that particular what example I have been giving for the termination, if that particular client is not giving any information to me, I will bring down the questions that okay, whatever the time he has served in the company, how was the behavior of his colleagues with him, how he used to feel when he used to go to office, what was his termination period, do he have any appointment letter with him? So indirectly, directly, you have to take out the information by making questions to yourself.
Yes, ma'am. Thank you so much. My other question was that you talked about how, in our kind of flow of the meeting, we need to first introduce ourselves. And you said, ma'am, exactly what should we include in that in terms of our experience and expertise? What exactly are we including in that?
Okay, okay. One of the thing that I used to do and I still do whenever I am having a client meeting. So it is not a surprise that somebody is going to come to me. I got to know that okay, this is, for example, AZB, AYZ companies coming to me for their client counseling. I don't know what specific topic they are gonna ask to me, but I will read about the company first. I will read that what does the company do, what is their service area. First, I understand that. I will prepare my introduction from that perspective. So, for example, if there is a aviation company, they are coming to me for a client counseling, I will make my introduction from the perspective that I have done. I have worked with the aviation sector. I have worked with the companies for their litigation in aviation in the consumer forums. I will not mention wholesale about the aviation, but I will make my introduction from that perspective that the client feel that okay, I have a relevant information. If you have any example, I can also elaborate on that point.
No, ma'am, I think I got the gist of it. Essentially, that you have experience in the field that they work in. is
that they work, but not to emphasize a lot that they feel okay, this is a made up introduction. So always try to make it in a way that it feels relatable, but yet not made up.
thank you so much, ma'am.
Thank you.
Thank you for answering that question, ma'am. We have another question from team 060. Kushi, would you like to go ahead with your question?
Ma'am, I would like to ask that how we should introduce ourselves to the client that you have answered already. And my second question is that we have not to become the therapist of the client, but we should maintain the friendly relations and but we have to set up the professional boundaries also. So how do we balance with that?
Okay, so this is very crucial part of the field, that when a client share information with you, they feel that okay, now I can call 24/7 to the lawyer and have a conversation. What you can do is, Max, just talk about the case. After reaching to a point, after introduction, after doing particulars of the work, just try to stick to the case itself. Don't ask them how they're doing in their personal life now. Just ask how they are, but not more particularly with their personal life. When they are trying to go to into their personal details, switch the conversation to a professional one. Switch the conversation about the case. So, for example, this happens mostly in the personal cases or individual cases, as mentioned. So, if somebody is going through divorce, he or she must be very sad and lonely or very emotional drained at that particular time. Initially, you have to take inputs because you have to prepare your case. After your a point of time, when he or she is trying to bring up the facts with their families and everything, try to change the conversation, make it professional, and make it like that you have other clients also, you have other works also to work upon. So you can prioritize, but the work wise only.
Okay, ma'am. Ma'am, my another question is that how we ensure the client that his information is confidential and it will not leak to anywhere else.
Okay. Okay. So there are every lawyer have their different type of modes to communicate the same. When you are dealing with the corporates, then either they're gonna give you non-disclosure agreements, or if they are not giving, you can give the non-disclosure agreements to them. If you are dealing with the individual client, you can make them aware in the very beginning that this is the confidential information. जो भी आप मेरे साथ बात कर रहे हो, this is a privileged information. If you want only, then I will share this. Otherwise, it will be between me and you. So when you will say these kind of words, not sure in Hindi, not sure in English, how your client is, then you want to achieve that, because it will go into the mind of the client that, okay, there is something known as confidentiality. But try to always communicate it, which will be understandable to your client.
Okay, ma'am. Thank you so much, ma'am.
Thank you.
Thank you for answering that question again, ma'am. Do we have any other questions, or will that be it? I don't see any other questions in the chat box. Okay. So thank you very much for that session, Niharika ma'am. Thank you for taking the time to answer the questions as well. It was not just an informative session for the participants, of course, who will be needing those skills in our upcoming client counseling stage next week, but also for us as organizing committee members to have the insight and the expertise that you have, and to be able to learn from that was very special for all of us. So thank you for taking the time, Niharika ma'am. Thank you to all the participants for attending as well. We will see you in the next round. Thank you. Have a good evening, everyone.
Thank you, everyone, and all the very best for your competition. If you require any kind of suggestion or anything, you can also reach out. So, thank you so much.
Thank you for that, ma'am. Thank you, everyone. Have a good evening.
Thank you so much. much, Niharika, for joining today. It was an absolute pleasure. Me being as a like working as a counsel, still I have been able to gather a lot of points today from this session. Especially the R rule has been something a game changer for me as well. So I really appreciate the session today, and thank you for being so informative throughout. I hope the
Much
participants.
appreciated.
Thank you so
Much
much.
appreciated. Thank you so much.